Hello, I'm attorney Dan Marr from the Nashua law firm of Hamilton and Kerrigan. I've been practicing law in New Hampshire for approximately 36 years and in the Commonwealth of Massachusetts for approximately 28 years. And during that period of time, I've dealt with a lot of business contracts and individuals with businesses and business-to-business contracts. I'm going to be talking today in New Hampshire what happens when you have contract terms that you think are part of the deal, but they're not in the writing. I'm going to talk specifically about how the New Hampshire courts interpret the contracts. So I often have situations where clients or the other side goes this, but that's not what we agreed to. If I'm representing the person that has the written provisions of the contract that are in my favor, I'm going to be absolutely stating the contract speaks for itself, and that's the entire interpretation of the contract. What happens under New Hampshire law is there's something called the parole evidence rule, which basically is a rule that says if your contract is unambiguous, so it covers this term and it says something very clear in regards to it so that a judge can look at it once and understand it so it doesn't need more interpretation, then he or she is not going to take outside information. So the person on the other side says, but that's not what we agreed to. We had conversations and he promised this, but the contract says that, you're going to have problems in enforcing it. So it's really important in any type of business contract that you have, also consumer contracts, but I'm focusing in here on business contracts, that if you have somebody on the other side saying, this is our boilerplate language, we never change it, for one, that's probably a lie. But if they say that provision that we never move off this, but we don't enforce that provision, outside of it being a bank or some other higher up institutions, banks, I certainly do know that their contract terms are usually enforced, only written the way they are. But big commercial landlords, no. I mean, you look at, maybe if you have a place that you're negotiating a 3,000 square foot pizza parlor, you can rest assured the 40,000 square foot grocery store or Rite Aid or whatever else, pharmacy, whatever it may be, has negotiated a different lease than yours. You may not have the leverage to negotiate things, but the idea that they never change these terms, just not honest. They change terms. On banks, less so, but many of them do, and you want to talk to your attorney to figure out what's going on with that. But in the interpretation of those contracts, sometimes the best decision you can have is to walk away from one of these deals. If they insist on something that's really important, and they say they're not going to enforce it, well, they wouldn't put it into the contract if they didn't want the option to enforce it. And again, under New Hampshire law, if the contract says this, and you say, well, they agreed to that, the courts are likely to say, no, you're stuck with this, what's in the contract, what's in the written terms. We're not going to hear, the judge is not going to hear oral testimony as to what else was agreed to that would contradict the clear and unambiguous terms of the contract. So that's important. Now, if things weren't discussed in the contract or the contract was inartfully written so that it's ambiguous, the court will take what they call extrinsic evidence, outside evidence, including oral testimony, texts, or the like, emails, to deal with that. But generally, they won't take that extrinsic evidence, including even if it's an email or a text that was leading up to the contract. They're not going to deal with that if the contract itself is clear and unambiguous. So that's very important to understand. So when you're dealing with these issues, I like to keep it, the KISS approach, keep it simple, Simon. I like to make my contracts clear so that not only both sides understand it, but also if it's in front of a judge, the judge can clearly understand it. And sometimes if there's like a bonus or a calculation of how profits are going to be established in the pricing of the contract, I'll put in examples. And I think examples are well worth it. Some attorneys don't like them, but they're the ones that like to talk above you and act like they don't, a contract's not a contract if you can understand it. I like good fences make good neighbors. Good contracts are ones that you can read and clearly understand. So examples work sometimes in like bonus structures, formulas for pricing of something, of how the person's going to get paid out, and you give examples of, oh, in this situation this happens, and in this situation that happens, and then it's clear. I like them also for bonuses and for executives as well, for clarification, but also in contracts when you're dealing with not only just as flat fee, but you're also getting some type of vigorish, some profit at the end, how that's calculated. That's all important. So if you have questions in regards to this, I'm here, Dan Marr at Hamlin Carrigan at 603-883-5501, 603-883-5501. Our website also has my bio and then all my weekly blogs, so you can look at any of those or get more information in regards to me or anybody else in our firm. And that's NashvilleLaw, all one word.com, NashvilleLaw.com. Look forward to opportunity working with you if the opportunity so arises. Thank you.